Number 3 is the burden of proof instruction from the pattern instruction.
Okay.
Number 4 is the duty to deliberate.
Okay.
Number 5 is the definition of possession of depictions of minors engaged in sexually explicit conduct in the second degree.
Objection.
Instruction 6 is the definition of minor.
No objection.
Instruction 7 is the definition of knows or knowledge, knowing or knowledge.
No objection.
Instruction 8 is the definition of intent.
No objection.
Instruction 9 is the definition of photograph or printed matter.
No objection.
Instruction 10 is the definition of sexually explicit conduct.
No objection.
Number 11 is the elements or to convict instruction.
No objection.
Number 12, the defendant is not required to testify. Jury may not use that fact to prejudice him in any way from the pattern instruction. Instruction 13 is the process of deliberation
No objection.
and the verdict form.
No objection.
Thank you. Anything from the state?
I should just note, Your Honor, that I believe it was number 12 was proposed by the defense, which is the defendant not testifying, and I obviously have no objection to that instruction.
Thank you for correcting the record. What we're going to do is make copies for the jury, then we'll come back on the record. I believe it'll be 10:15. We'll be ready to read the instructions and get started.
10:30.
Excuse me, 10:30.
I thought I wanted to bring to the court's attention that the statement made in motion to eliminate other suspect evidence.
Okay.
And Your Honor has now heard all the evidence, so our offer of proof would be what we have here is a case, Your Honor, involving largely circumstantial evidence of possession and or knowing possession. The question would be whether the states have, circumstantially, I think we have images on a disc found allegedly in Stephen Powell's bedroom in a box. It's unlabeled. The disc is unlabeled. The box is unlabeled. It's in a stack of boxes. Appear to be stacks of boxes in other parts of the homes. Lots of computers taken from the house. Lots of digital media taken from all over the house, and multiple other people living in the house. And specifically, at least one other person living in the house back in 2006 when A.H. and J.H. I have that right? Yeah, A.H. and J.H. were residing in the neighbor house, and that on the disc in some subfolders were images of Mr. Powell, but there were also images of other individuals. ID is always a question mark. The defense that was could be identified in the omnibus hearing on this case, Your Honor, was general denial. Case law is a little tricky when you look into other suspect, when you're talking about arguing on a case that's basically based on circumstantial evidence, saying that he's specifically the one who either possessed or took the images, which would be, or knowingly possessed or took the images would be the question here. So I guess they have the same model camera was found in the house also, and then they have a journal entry that suggests that, which I think goes more towards the intent element of the possession, of whether or not it's maintained or possessed for purposes of the sexual gratification. But there's still a question of, well, was it either taken or possessed by Mr. Powell, knowing what was on the contents of his disc. So it's a fairly circumstantial argument, and I think the defense is still, although I would be precluded from saying, okay, this must have been done by somebody else, because that would require some additional level of evidence to suggest that somebody else did it instead of Mr. Powell. We're right, I think, at that level, given that it's, the case law when talking about other suspect says, well, the defense needs to be allowed to generally put on their defense, but you can't just point the finger at anybody without any evidence at all to suggest that. But when you have largely circumstantial to suggest it's him, and I think those cases are mostly talking about, well, okay, you point out that, okay, it must be Joe Blow, the car thief, that did it instead of my client, the car thief, or something like that. In this case, it's all possession in the household with other individuals living in the household. So the state does have circumstantial evidence that tends to point the finger at my client. But it's really only good as the strength of that circumstantial evidence. So, the defense case would be arguing, okay, well, if it's other things are found around the house, it's in boxes, it's not labeled. Can you tell this wasn't just a copy off of one of the computer's hard drives and saved at some point? That Mr. Powell had access to a computer, other people had access to a computer potentially. Or, we don't. Is it possible under those circumstances that all this stuff was saved onto a disk and it'd be there without Mr. Powell's knowledge? So that would be what is, I guess, the argument that we'd be asking to be allowed to put forward as far as our defense goes. So I think it is on the edge of that sort of evidence, and that's why I wanted to bring it to the court's attention, because it was the subject of a pretrial motion, and I agreed that we would discuss it with the court outside the presence of the jury before going there. But I hope I've made clear what I think the arguments would be, and the arguments that I should be allowed to make, Your Honor, would be that far.
Okay, yes, sir.
Your Honor, for the defendant to introduce other suspect evidence, the defense has to provide proof of a connection with the crime. And this is from State v. Downs, from my trial brief, and State v. Mack, my original trial brief that was filed 3 years ago. There has to be proof of connection with the crime such that a train of facts or circumstances as tend to clearly point out someone besides the accused as the guilty party. What Mr. Curry has introduced here is that there were other people living in the house. He's provided no evidence that any of these other people took the photos, because we know beyond a reasonable doubt that the defendant took the photos based upon his multiple convictions for voyeurism. He's provided no evidence that any of these other people had access to the room. He's provided no evidence that any of these people had access to the disk. He's provided no evidence that any of these people put the photos on the disk. The only evidence in this case is that the defendant did all of these actions. It's the defendant's burden to provide some evidence that someone else did this, other than just a sort of general, there were other people living in the house type scenario. I think the defendant's precluded from arguing other suspect evidence because they have not met their burden as required under the case law to be allowed to do so. So I'd ask the court to preclude them from arguing, and it's frankly transparently obvious to me that the attempted argument is going to be that I believe John Powell, the one that was described as the mountain man that wore a bathrobe walking around, was the one who did this. There's simply no evidence to support that assertion at all, and they're required to provide such evidence, like testimony, for example, saying John Powell was known to take photos of young girls, or Josh Powell was known to take photos of young girls. Something along those lines, some sort of evidence here, and they haven't done that. So I'd ask the court to preclude them from arguing other suspect based upon the relevant case law.
I respond, Your Honor. The instructions refer, if we had the multiple counts before us here today, they'd have to be deciding every count individually on its own merits. They're not based on, in fact, they're supposed to ignore a ruling on any particular other count based on when determining this count. Other than the location being by the door in Stephen Powell's bedroom, a journal entry found somewhere else that discusses, I like to look at girls, and it doesn't say naked, it doesn't say, it says in various types of clothing. That the fact that it was his house, his bedroom, that's the extent of the evidence that they put on to suggest that it was Mr. Powell that did these. They haven't, she's saying they proved beyond a reasonable doubt. And what they have presented is, what they have is circumstantial evidence that a jury might find beyond a could rule and could say, we believe based on that evidence that in fact it was him. But to then suggest, well, just because the circumstantial evidence would be weaker than somebody else, we know that there's other pictures of other people in the family on the disk, that there's thousands of files on the disk. I couldn't it have been? Now, jury may well find that it's much more likely that it was Mr. Powell, based on the evidence that they heard. They're free to do that. They get to consider the weight and the strength of the evidence. I'm just talking about what evidence we actually have. Is there some circumstantial evidence to suggest, the circumstantial evidence that they have is they're trying to argue, to suggest that it must be Stephen Powell that does it. And I'm saying that there is some circumstantial evidence, or that the strength, I want to argue the strength of that circumstantial evidence, John.
So,
like I was allowed to do in the first trial.
So, we need to divide one into two. First, I'm going to rule that the threshold hasn't been met for other suspect evidence. There's been some discussion about a person described as, I think it's John Powell, who is, I believe, a son who lived at the house an undetermined period of time. I don't think that a foundation has been laid to establish John Powell, or I believe there was a daughter that lived there for a while. Well, two daughters lived there at different times.
And actually another son later.
And Josh Powell lived there at a time. So, but I haven't heard any testimony at all suggesting that any of those other people took any pictures, did anything, and so I'm going to preclude any other suspect evidence. Certainly the defense has a right to argue, on the other hand, that the state hasn't met its burden beyond a reasonable doubt, and so I believe you can argue however you need to argue what you think those doubts are, particularly since this is a circumstantial in part evidence case. And so I'm going to leave it there. Okay. Any other housekeeping matters? Okay, I think we're ready to make copies, and it'll be about 10 minutes, and we'll come back and try to get this wrapped up.
You sure? Okay.
Travis, if he's got to use the bathroom, I don't-
Yeah, if you've got to use the bathroom, use the
I don't care
bathroom.
if it's 17 minutes.
No, yeah, I'll just go.